Good morning. For the record, I'm William Butler. I represent Michael Booth. He's right here beside me.
This YouTube star, once known as Mr. Crafty Pants, the glitter-loving DIY influencer with hundreds of thousands of followers, is now in some hot water, to say the least. Today, he sat in a Kentucky courtroom facing more than 24 criminal charges for possession and distribution of child sex abuse material. And the latest hearing just raised new questions about what comes next for the YouTube personality. We're on the case, presented by Law&Crime. I'm Chris Stewart. Before we dive into this episode of On the Case, very shocking, disturbing story out of Kentucky involving a man who so many people watched on YouTube just trying to learn how to do crafts better. I do need to talk about our partner and sponsor, Morgan & Morgan, America's largest injury law firm. They sponsor this episode of On the Case. They, with their more than 1,000 attorneys, have recovered more than $25 billion for their more than 500,000 clients. In the past few months alone, a client in Florida received $12 million when insurance offered just $350,000. In Pennsylvania, another client was awarded $26 million. That is 40 times the insurer's offer. Morgan & Morgan makes it so easy to fight for what you deserve. You can even start a claim on your phone. So if you're injured, you can start a claim at www.forthepeople.com/OTC. You can also scan this QR code on your screen or click the link below. Today, for the first time, we saw the YouTube personality, that person who had the smile on his face, who brought joy to a lot of people on the internet, in a much different kind of light. We saw him in court for the first time as a defendant in a case where he is accused of possessing and sharing child sex abuse material. We're talking about a man who on YouTube went by Mr. Crafty Pants. Now, this case is far from over.
All right, Mr. Booth, just hold his hair, okay?
Good morning, everyone.
Good morning. For the record, I'm William Butler. I represent Michael Booth. He's right here beside me.
Mr. Crafty Pants, in real life, is 39-year-old Michael David Booth. He is accused of distributing and possessing child sex abuse material. Investigators say the cheerful DIY influencer's online persona hid something far darker. According to authorities, they say they traced images of minors shared on a messaging app straight to his Prospect, Kentucky home. The hearing raises new questions about Booth's next steps in court and what could happen as this shocking case moves forward. But to understand why this hearing matters, we need to look back at this case against Michael David Booth. Now again, he is known online as Mr. Crafty Pants. He was once a cheerful, glitter-loving DIY influencer with hundreds of thousands of followers, not just on YouTube, but on Facebook and on Instagram. His tutorials on t-shirts, cards, home decor really made him a beloved figure in the crafting community. But behind that friendly persona, police say Booth was allegedly involved in something far darker. In early August, authorities traced a social media account on the messaging app Kik distributing child sex abuse material, and they traced it straight back to Booth's home. That home is in Prospect, Kentucky. Investigators say the account contained 6 images, 3 depicting children under 12, shared at least 10 times, and 3 showing teenagers shared at least 15 times. 2 selfie-style photos tied Booth to the account. On October 22nd, Booth was arrested and charged with 10 counts of distributing matter portraying sexual performance by a minor under 12, 15 counts of distributing matter portraying sexual performance by a minor over 12 but under 18, and 3 counts of possession of matter portraying sexual performance by a minor under 12. And then 1 count of possession of matter portraying sexual performance by a minor over 12 but under 18. So you can see there are a lot of counts we're dealing with here. In fact, there are 25 in total. Booth appeared in Jefferson County District Court the next day. He entered a not guilty plea to those charges, and he was released on a $100,000 cash bond with strict conditions: no contact with minors and no access to the internet or social media. Today, Booth returned to court for a preliminary hearing before Jefferson District Court Judge Amber Wolf. Here's what happened.
Case number 32, Michael Booth. All right, Mr. Booth, just look at the total here. Okay.
Good
morning, everyone.
Good morning. For the record, I'm William Butler. I represent Michael. He's right here beside me.
All right. And it says here that you all are agreeing to waive the probable cause hearing and send this case to the grand jury for the week of, it says 11/24, although the grand jury week is 12/1. Is that a special week?
And Your Honor,
Yes, you're okay.
We're gonna withdraw our request to for a hearing over the bond. We'll just leave it the way it is.
Okay, bond will remain the same. This case will be sent to the grand jury for the week of December the 1st.
Perfect.
Okay.
Thank you.
Booth and his attorney waived a separate probable cause hearing, which is typically used to determine whether there's enough evidence to move forward with a case. Instead, the matter will go directly to a grand jury for review. The judge also confirmed that Booth's existing $100,000 cash bond will stay in place, meaning he remains out of jail under the same conditions while this case proceeds toward a grand jury review the week of December 1st. Joining us now to talk more about this is criminal defense attorney and former prosecutor and partner with Zealous Advocates, Jeremy Eldridge. Always great to have you on Law and Crime. Thanks for being with us to talk about this. Is a disturbing case, and it involves someone who, to hundreds of thousands of people on YouTube, was kind of a celebrity. When it comes to these cases, before we get into specifically what he's accused of, just what stands out to you about this suspect who went by Mr. Crafty Pants on YouTube, and he made good money doing it seems.
What stands out to me the most is whenever you see an individual that's charged, and a lot of these people are middle class or upper middle class, they hold good jobs with military, policemen, firefighters, upstanding people in the community, and that is the first thing that comes to a surprise to people. But what stands out about Mr. Booth's case is that when you have somebody that works with children, when you have somebody that their target audience on YouTube is children, when you have somebody whose Halloween signs outside of their house say, "I smell children," that it makes it even more troubling, because then you start wondering, was it just photography? Was it just videos that you were interested, or have you had face-to-face interaction with children, and are you a child sexual predator? And it always begs that question when you're talking about someone who's charged with child pornography and then also has employment or is interested in working with children.
Because I think from the stories that are, the cases you've worked, the stories I've covered, at this point we both know the idea of saying like it's the last person you would ever expect. So often we see it's people who might be a leader in the community. In this case, he was someone who was kind of this cheerful guy as a public persona, but then behind closed doors, allegedly it was very, very concerning. Today in the court case, and he's facing several charges, the judge and the court decides that this is going to move forward to a grand jury. I know each state is different, this one taking place in Kentucky, but what does this mean about where this case is headed?
What's happening is really routine procedure. When you're talking about somebody that is charged with a variety of felonies, what happens is that in some states we would call it being set in for a preliminary hearing or being forwarded to a grand jury. What that means is that a grand jury is a group of people, usually between 30 and 60 people, and those individuals hear felony cases and decide whether there is sufficient evidence or probable cause to forward the case to the next highest court. Meaning, is there enough evidence to believe? And it's a very low standard. Probable cause is essentially a more likely than not standard at this point. It's certainly not beyond a reasonable doubt. That's the standard for most criminal trial courts. And so here, the state's attorney or the DA is allowing the grand jury to make that decision, to hear probably the police report, which would be sufficient. A detective may get on the stand and read it to the members of the grand jury, and then they'll say, yes, we believe that there's sufficient evidence for the case to move forward, meaning the felonies to move forward. And that will simply help the case progress and for the felonies to continue in the process. It doesn't mean he's guilty. It doesn't mean he's going to jail. It simply means that there's enough evidence to substantiate the felonies that he's been charged with.
I'm not sure what his financial situation is, but is being held on a $100,000 cash bond. What does that mean about how much he would actually have to? Is it $100,000 he would have to put down to be able to get out of jail?
It's a great question. The judge would have had two choices in imposing a cash bond. One is a cash-only bond, meaning that someone would have to go to the court and literally bring a cashier's check or something for $100,000, and that would suffice. And there's what's called corporate surety, which is what we would typically call a bail bondsman, where a bondsman can go put down 10%, for instance, and then that would suffice to allow the individual to be out. And then obviously if the person fails to appear in court, the bondsman catches up with them. Here, it appears as though it is what was typically referred to as a cash-only bond.
This case, it's taking place in Kentucky. He's facing state charges right now, but I mean, this is these images were shared on the internet. Who knows who was on the receiving end of them? How likely is it that the federal government could get involved in a case like this?
Oftentimes, whether the federal government gets involved is a matter of leverage in negotiating. Having handled a lot of these cases in Maryland and in federal courts, what ends up happening is that the state prosecutor is going to make a plea offer at some point. And if that individual accepts the plea offer, the case can resolve in state court. But a lot of the times when state defendants do not accept plea agreements, the state's attorney's office prosecutor can say, look, then not a problem, we'll send it to federal court. And the fear there is palpable. The fear there is that the penalties are stiffer. There are mandatory minimums for child cases like this of 5-year mandatory minimums, meaning 60 months. And that's where the sentences start in federal court potentially. And so there's a lot of leverage that DAs have to say, if you don't want to resolve the case here, we'll send you to federal court. And there aren't a lot of types of cases where that interplay occurs. In fact, child pornography cases are one of the few types of cases where prosecutors will threaten federal prosecution, assuming they have that good partnership with the U.S. Attorney's Office in that jurisdiction.
And in this case, he's pleaded not guilty, and I know that that's procedural in a lot of ways. No one's going to plead guilty right out of the gate. But it does seem like prosecutors have some pretty strong evidence against him. Not only that he shared these images, they apparently have selfies that just prove it's him. I mean, that's almost a smoking gun. What is the defense that you see in a lot of these cases for someone where prosecutors can say, this was your IP address, you shared these specific images, and by the way, we have a selfie of you related to these images that seems to just lock in the fact that it was him sending these?
Most of the time when you have criminal defendants that want to take these cases to trial, their arguments seem to revolve around what they're saying is access to that device, to say this is a laptop that multiple people within the residence use, or this is a cell phone that multiple people within the residence use. Recently, I've represented a gentleman who was an older gentleman. He got a new cell phone. His older cell phone was given to another member of the family who resided in the same residence. They were both on the same Wi-Fi. There's an IP hit to that residence. And when the police arrive, there's a question as to who's the one using that device. And so most of the time, it's really a matter of access to the device. It's not a matter of whether that's individual. So to your point about if they have a selfie, that's going to be something that's going to make it more difficult. And to further that point, one of the other issues in Kentucky is there's a rebuttable presumption in Kentucky that if you're in possession of child pornography, that you intend to distribute it. Now, it's a rebuttable presumption, so if he goes to trial, he could certainly produce evidence to say, this was for my gratification, it was not necessarily for distribution, but that's not a great place to be if you're a criminal defendant in trial court.
I know he's accused of distributing the images, I think it's 6 times. That'd be disturbing if someone had an image and distributed it one time. In these cases, how does the number of times that someone is accused of distributing it impact the type of charges that they're facing?
Yeah, once again, great question, because that supposedly was from his Kik account. And the one thing about the Kik account is you have to assume that it was intentional sharing. And the reason I bring that up is there are a lot of cases charged across the United States for passive sharing. You download a BitTorrent in your home, whether BitTorrents work in a way that it's passive sharing. So you're trying to download a movie, for instance, the new Mission Impossible movie, and everyone else has it, and it allows you to download it faster. It's the point of a torrent. Well, I've seen people with child pornography cases that go, I didn't intend to share this. I downloaded it. Yes, I had the material, but I didn't intend to share it. And in passive sharing cases, frankly, it's not a defense, but a lot of people think, well, I didn't intend to share it, not understanding how a torrent works. With this Kik app, however, it appears as though this was intentional sharing. It was him potentially sending this to other people. And there's a difference because prosecutors view those cases differently. They really do, because prosecutors understand the difference between intentional sharing and passive sharing, depending on the platform utilized in order to share this material.
How do prosecutors and law enforcement kind of tap into this world? Because it does seem where this stuff is being shared, it's not Facebook and Instagram. It's not the surface level stuff that most people are on the internet as. It's in a deep part of the internet or maybe it isn't, but just a part of the internet that most people typically aren't on. How do you get access to it to figure out who is sharing this stuff?
First off, you're actually, it is, they get alerts from Google, they get alerts from Microsoft. You'd be surprised. Some people go in and make zero effort. They treat it like they're watching regular pornography or that they're looking for ESPN. And that's how they get caught, because some of your web browsers will immediately alert law enforcement. But to your point, which is the more nefarious and the more common conduct, that's dark web stuff. There are some non-governmental organizations that do, whether it is, obviously if you're not a governmental entity, you're maybe not beholden to the Constitution, maybe an invasion of privacy. If I were to say that it was an infringement, I say that because there are some organizations that monitor people's devices and will reach out to law enforcement and say, hey, this is what we've seen. This is the kind of traffic we're seeing. Or people that comb the dark web that are trying to hunt people like this and will turn them over to law enforcement. And so you do get a fair number of anonymous tips. But I would say the lion's share of these honestly come from internet providers. Comcast, Verizon, they have systems that are built in to detect this traffic. And then they'll alert law enforcement. Law enforcement will get a court order for the IP address. Who owns that IP? Detectives then go to the residence, interview people. A lot of people may have never, especially first-time offenders, don't know any better or think, I'm supposed to cooperate with law enforcement. They immediately make admissions, they turn their devices over, and then their cases are essentially indefensible. And an attorney like me is simply trying to get maybe the best result for them, which is treatment to make them not recidivate and potentially lessen whatever sentence they're facing by trying to organize a good guilty plea. But a lot of it is getting somebody into treatment, figuring out why it's happening. And just to say this, a lot of individuals that are engaged in this behavior come from situations where they experience a lot of trauma. They were victims of child sexual abuse. There's a lot of literature out there to suggest why people engage in that behavior. Not that it's all excusable, but it does help explain the human behavior.
No, and I think that's a good point. And just thinking of what the defense could be when you get to a sentencing portion, can you tell a story that a judge or a jury might find somewhat sympathetic? When it comes to finding who he was sharing it with, and gosh, who the children are in the images, what is the process, whether it's a prosecutor's office doing the investigating, a law enforcement agency? You have this person here, and if he's guilty, Michael David Booth, of possessing this material, how do you find out where it came from, who's in the video, and where it was going?
Some of that would also come down to whether he would choose to cooperate with law enforcement and share that information. A lot of the time in these cases, the individuals don't necessarily know the identities of the individuals they're sharing them with, but they might be part of a group of individuals that have agreed to share this sort of material for all of their collective benefit. And so even if they wanted to say who it was, a lot of the time they can't provide that identity, and law enforcement may track the other individual's IP, but with the advent of technology to mask IPs or to offer other layers of protection, a lot of the individuals engaging this behavior are not unintelligent. So they've tried to put together precautionary measures to protect themselves from being discovered by law enforcement. So it really is difficult to figure out who this material is sent to. In fact, in handling hundreds of these cases, in my time as a defense attorney, which is almost 20 years, I can only count a handful of times where law enforcement, outside of arresting the individual who they believed was in possession and or distributing, were able to figure out who else they were distributing it to just because of how it's shared on the dark web.
Assuming that he's indicted by a grand jury on December 1st, and assuming that all this evidence is true, that they have a selfie of him, they have the IP address, they have the intent that he was sharing it, if prosecutors have a really strong case, I mean, how soon could a defense attorney, if he's willing to cooperate, make the phone call that they're looking for a deal? How does that process work?
Almost immediately. If he actually has information to share, almost immediately. If he's part of a ring of other men and women that are manufacturing and distributing child pornography, if he knows of other individuals that he's sharing this material with and he sought to cooperate, he could certainly walk himself into a greatly reduced sentence. There's a lot of creativity when it comes to being a defense attorney and being a prosecutor. If you think somebody could be helpful to you, you could talk about felonies versus misdemeanors. You could talk about sentence structure, meaning jail versus probation or jail, home detention, and probation. But undeniably, there's a very high likelihood that he'll end up being on the sex offense registry, and then depending on what charge he's either found guilty of or admits to would determine the length of his time on the sex offense registry.
And then when the grand jury hears this case, could the grand jury decide whether there are more charges that he could face, or is it going to be set at the dozens that he's facing? I think it's 25 total that he's facing right now.
No, it's more likely that the DA will select a group of charges that they find to be appropriate. They will present those charges and then a copy of the police report or limited testimony through a detective to the grand jury, and the grand jury will decide if those charges work. If prosecutors decide after, for instance, they have what they have now. Let's say that they're still downloading cell phones or they're still downloading other devices through a program called Celebrite, and they discover that there are more images. They find that there's more criminal or nefarious behavior. They're certainly welcome in the future because a lot of states don't have statute of limitations on felonies, and it's so early that they would have more than sufficient time to issue what's called a superseding indictment and add other charges. But that's well within the discretion of the prosecutor.
All right, we'll see what happens next to Michael David Booth. December 1st, the grand jury will hear his case. Jeremy Eldridge, criminal defense attorney, former prosecutor, and partner with Zealous Advocates. Thank you, sir, for being with us. It's always great to have you on Law&Crime.
Thank you for having me on.
This case is now set to go before a grand jury the week of December 1st, where prosecutors will present evidence to determine whether Booth will face formal indictments on the more than 24 charges of possession and distribution of child sexual abuse material. That will do it for On the Case, presented by Law&Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.